Hello, and welcome to ICRC-TV HR Updates. My name is Pandy Pridemore, Principal Consultant with the Human Resource USA. This is going to be a topic that we have never really delved into. Today's show is on foreign workers. And why not? Think about what's going on all over the country. We've got more and more foreign workers coming into the workplace, and yet who's preparing our employers and our businesses and equipping them with the information on all the legal requirements to do this properly? Well, you know me. I brought in the experts. Today we've got one of our absolute favorites, and I say this every time he's on because people ask for him. Carl Ulrich from Sibley, Shillitoe, and Dyer. And with him, he's brought his associate, another partner, Josh Sherlow. Both labor law attorneys, both absolute experts. And Josh, he even focuses more on the immigration side than, well, just about everybody else I've had on. So this is the show you want to actually sit back and take in, because we're going to see more and more and more foreign workers in our workplaces all over the country. I do have a training tip for you. So remember, write down your questions and be prepared to send them in, because this show is all about you. So let's just get started. Carl Ulrich.
Hi, Pandy. How are you?
I'm good.
Good
It
to
has
see
been
you.
a couple months, though. We have to admit it's been a couple months.
It's nice to be back in the studio again.
Well, and thanks for bringing your colleague.
My pleasure.
You're a newbie.
I'm a newbie, first time.
Should we be gentle with him?
I think we should be gentle with him for
You
now.
did okay putting his microphone on.
That was step one. Yeah.
Right.
It might be the most challenging step. So
And we had a mug for you.
we had a mug.
Okay, labor law, you know, everything's been COVID up to this point.
Sure.
And everybody's been so focused on this, but at the same time, we've got this movement that we've got to be aware of, because there are so many different aspects of dealing with foreign workers. And let's kind of start there, Carl. Mm-hmm. Let's talk about all the government agencies that have some kind of input on a foreign worker coming into the workplace.
Well, the list is a long one, right? Well, I mean, we're in an environment, in a world where it's harder and harder to find help. We've got a growing, expanding economy, at least we hope so. But there's a real restriction and inability to find workers these days. So naturally, where would you look? If you're looking for some expertise, you can't find it locally, you might look outside of the borders. And so that's where immigration law comes in. Yeah, we have a lot of government involvement in that process, as you well know. So we start with the Department of Labor is one place where regulation occurs. The Department of Labor is interested in making sure that foreign workers are not supplanting existing labor here in the United States. So if we have U.S. people who are available and ready to work, we don't want to, dispossess them of employment with foreign workers. So the Department of Labor kind of vets that piece of it, making sure that we're not undercutting the prevailing wages in the marketplace. That's sort of the Department of Labor's piece of it. We can talk more about that in detail later, but then of course you've got the United States Citizenship and Immigration Service, we call the USCIS. And the USCIS is the agency, it's a part of the Department of Homeland Security, which sort of reviews all the immigrant petitions, all the visa requests, all the employment authorization documents that a foreign worker needs to come to the United States to be physically here, and then also have the authorization to work in the United States. The USCIS is the agency that sort of reviews those petitions, makes sure that everybody is qualified, that those petitions are properly supported with the right information, and that they fall into the correct categories of visas and authorizations. So the USCIS does that piece of it. We also have the Department of State, which is, you think of Department of State, you also think of diplomacy, right? You think of diplomats and you think of foreign consulates and embassies. And that's part of it. But the Department of State, as you know, in foreign countries, the U.S. has embassies and consulates there, whose part of their responsibility is to provide visa services for foreigners coming to the United States. And some of those are foreign workers as well. So the Department of State may get involved at some point in some processes in issuing visas to folks who are outside of the United States and want to come to the U.S. So they will also work hand in hand with USCIS in that process. And then, of course, you have the Customs and Border Protection people, the CBP people. And those are the folks who police the borders. So you come into the United States at Chicago O'Hare Field or one of the airports, or you cross the border from Mexico to the United States or from Canada to the United States, you will usually be seen by somebody at a CPB person who will check your documentation and either grant you or deny you entrance to the United States. So they are involved too. And we have ICE, Immigration and Customs Enforcement. And the ICE folks, I think Josh will probably get into this a little more later in the program, but the ICE folks are sort of the enforcement arm. They're the police of the immigration system. They will want to be involved in making sure that the foreign workers who are here, the foreigners who are here, have proper authorization to be here, have proper authorization to work. So they will enforce the laws for those who are physically in the United States, work with local and federal government enforcement agencies to do that. And so those are some of the key agencies that we look to. And all of those folks are involved in one form or another in what we do as immigration lawyers or as labor lawyers. And so we always have to be prepared to understand their procedures, their guidances, their rules, and sort of pass that information on to our clients.
Well, you brought up a really good point. So let me kind of circle you back on that. Most of the companies that I'm in contact with or who have sent in questions aren't working with labor law attorneys. Mm-hmm. So they're just bringing these individuals into the workplace. And what's interesting is what we would have thought that have always been traditional organizations or disciplines that have gravitated to foreign workers like IT, mm-hmm. Pharmaceutical. It's now changing and shifting again because of the labor availability. Manufacturers. Mm-hmm. Some of the more manual labor is now, they're seeking out foreign workers. So should those employers all automatically, before they even think about bringing in a foreign worker, talk to a labor law attorney?
Well, the thing about foreign workers is always that you have to find the right qualifications, the right position for the right visa, for the right author. There are certain silos into which you have to fit particular solutions. You have certain visas that are designed for particular types of positions. Most of those positions tend to be skilled or highly skilled or very extraordinary ability type of individuals. There aren't as many work authorization options for those at the lower skill levels. Mm-hmm. There are some, particularly in the agricultural context, but for most manufacturers, what we see is that folks who are coming to the United States are those who are rotational foreign executives who may come to a U.S. subsidiary for a few years and then return to their native country. There may be folks who have STEM type degrees, science, technology, engineering, math type backgrounds, mm-hmm. engineers, IT people mm-hmm. of those nature. There may be folks with technical or research and development backgrounds who are more highly skilled. Those are the folks that are more easily brought into the United States because that's the way the system is designed. It's designed to favor those with the greater skills for the most part. Mm-hmm. And it's also designed to make sure that when those folks are brought to the United States for positions, that they're done only after those positions can't be filled by U.S. workers. So the system, there are several steps you have to go through to verify that the position can't be filled here with domestic people before you go to the foreign worker option. So there are lots of reasons why that the idea of recruiting foreign workers it's complex, and if you've got the kind of business where you're looking for folks that might be living currently outside the United States, you probably want to talk to a qualified immigration counsel to understand the lay of the land a little better, because it takes some planning. It also takes a fair amount of investment in time and resources to make that happen. And the worst thing that can happen is you embark on a strategy of recruiting foreign workers or foreign expertise, and you find out ultimately that what you've done is heading in the wrong direction and you can't go the way you want to go. So you want to make sure that you've planned it out properly so that you make the most of the investment of time and resources and don't go down the wrong paths.
Well, it's interesting. Some of the comments that came in have been for countries that I just really wasn't, when I called you the first time, I was like, Micronesia?
Yeah.
And these were multiple employees coming into this workplace, again, manufacturing, with the employer having no preparation or understanding of all the different things that need to be taken care of, or at least prepared for.
Right.
Because these individuals are obviously not English-speaking employees.
Right. Right.
So maybe we should go about that. Maybe we should just start talking about, if you are thinking about, or if you have access to individuals that are already here in the country, which we are all aware, we've got foreign workers moving through this country and being distributed throughout. If we're going to take these individuals into our workplace, what should we start thinking about?
Well, there are lots of considerations, and the considerations depend to some extent on the type of work environment that you have. If it's a manufacturing, there are a lot of safety-sensitive positions. It's a situation where you may be wanting to make sure that certain safety rules are in place. Obviously, those rules have to be communicated in a way that the foreign worker understands. It's one thing to rely on someone's expertise. It's another thing to provide the same levels of protection that employers are required to provide to those foreign workers. You can't do that unless you understand and address whatever language issues may exist. Usually we find, at least in my experience, that the employers that I work with who hire foreign workers are hiring people with some language, some English language capability. I mean, especially in positions of high degree of skill and education and expertise, those folks are going to have some language capability to begin with, and they have to in order to understand and work with the American counterparts. Yeah. But even so, we talk about nuances. Technical language is technical language. I mean, I don't understand technical language in English half the time because I'm not an engineer, or I'm not an R&D guy. So when you're dealing with a language barrier on top of that, that's something that needs to be addressed. So certainly that's the issue. Just the onboarding process. I know as an HR person yourself how complicated and document-driven that onboarding process can be. And you're not going to change that process. In fact, you can't really change that process when you're bringing a foreign worker in. You have to go through all the same certifications, you have to fill out all the same forms, you still want to talk to them about the employment handbook, you want to make sure that they understand all the same things that a typical U.S. worker would understand in the same way and at the same level. Mm-hmm. And sometimes that can't be done in English. Sometimes you have to have the help of a translator, or you have to have the help of other resources, maybe a Spanish translation of certain things. Anyway, there are ways to address it. So there are all kinds of things throughout the employment relationship that depend upon your ability to communicate well. And sometimes that means you need to sometimes invest in language translations or assistance in that.
Well, and I love that you went right into that, because you and I work so well together. You knew what I was thinking. I had an organization more in the pharmaceutical industry who had an individual who English was a second language, obviously, but it was her articulation was so broken that they instantly said, nope, she has to stay over there, and she has to stay away from the clients. We can't have her on conference calls. Someone needs to just interpret for her. Of course, they didn't get a formal interpreter. And so let's talk a little bit about how easily we can get into that line of discrimination if we're not actually taking that seriously in terms of if we're going to hire them, we're hiring them for a job, let them do the job.
Right. Well, where I start with this discussion is I start with some of the basic ideas behind employment discrimination. You can't discriminate. The law still is and has been for some time that you can't discriminate against an otherwise legal foreign worker on the basis of their national origin or on the basis of their citizenship. As long as they're qualified to work in the United States, and as long as you've gone through that process that we talked about, and you have a better qualified foreign worker who's legal and vetted and gone through all the appropriate approvals next to a less qualified U.S. worker, you can't discriminate on that basis just because they're from a foreign country. So discrimination starts there. Those rules have been in place for a long time. And now, the other thing I'll say is that if you've got somebody coming in who's not qualified or not legally allowed to work in the United States applying for a job, not only can you discriminate against them, but you're legally obligated not to hire them. So that's a different ballgame. What I'm talking about here are those individuals who have done it the right way, who are here, who are permitted to be here, and you're now comparing that person may be better qualified against others who may be less qualified. You can't discriminate solely on or partly on the basis of their background or citizenship. So that's what I start with. But that doesn't end in the hiring process. And to your point, I think as you hire those foreign workers, how you treat them, what you do in the course of employment, the rules that apply, the expectations that apply can't be different for them necessarily. And in some cases, that takes a lot of effort. Because if you're going to invest in a foreign worker, you're going to want to be sure that they have the same opportunities to succeed as everybody else. Why else would you hire them?
I love that you did that again, because here was one of the questions. If we are trying to get more business in India, is it a discriminative act to hire an individual, a native from India, to only work with those clients and prevent them from working with other clients?
I think if you've defined the position in a particular way, if you say, we have this business line, it involves interaction with Indian customers, somebody who understands the culture and can relate to whatever language or translation issues that might exist. If you've defined the position in that way, that's a bona fide business requirement. Then I think you can fill that position targeting somebody with a background and saying, hey, this is your job. You're going to focus you on that job, and they come into that job with that expectation. I think that's probably not discriminatory. Again, there's a business reason for doing it. You're not discriminating, again, you're not taking similarly situated individuals and treating them differently solely because of their national origin or background. You're filling a position for a particular business need, which is a little bit different, in my opinion.
And we've done a previous show on offer letters. So in my thought process, that would be something that would be put into the offer letter, making sure that it's either in the job title or just a little bit of a purpose in the I don't want to say you don't put the job description in the offer letter, but just something to note that, correct?
Yeah, I think so. I think, we talk about, and I know you talk a lot about having written job descriptions as an important step in the hiring process. You document what you need, what your expectations are. All of that's a great practice. But if you're defining a position in a particular way around somebody with expertise and knowledge of a foreign country or a foreign customer base, yeah, you need to include that in the written job description and in the offer letter, as you said, because that's part of the expectation of the job. And that also prevents someone from later coming in and saying, oh, you're treating that person differently because of their background. No, we're treating them because this is the job we wanted to fill. That's why we're treating them that way, because this is a bona fide occupational qualification of this particular position.
Another question. If an employee feels like they're struggling with the understanding aspect of the language, is it the employee's responsibility to pay for the interpreter, or is it the employer's responsibility to pay for the interpreter?
Always the employer's responsibility. Part of the essential truth of that is that when an employer makes an investment in a foreign worker, they have to understand that there are going to be some issues that they may have to address. If language is a particular qualification of the job, and they like the person's background, they want to hire them, but they know the language is deficient, that's something they need to understand up front, and they need to be prepared to address with their own resources. It's not the employee's responsibility to solve that problem. It's the employer's responsibility. They're in charge of the workplace. They're in charge of the terms and conditions of employment, and they're responsible for ensuring that everybody's treated fairly and equitably under the law. So yeah, for the most part, that is the employer's responsibility. That comes up a lot, Pandy, in safety and health context.
Good point.
One of the things that OSHA has been talking a lot about over the years is that if you have foreign workers in your workplace and you haven't properly communicated to them the safety rules because of language barriers or otherwise, that's going to be an OSHA violation. And they're not going to cite the employee, they're going to cite the employer. The other interesting thing about that is when OSHA comes in and does an internal audit, one of the first things they will often do is they will sit down with rank and file employees, and whether they've got English language capability or not, but they'll sit down with rank and file employees and they'll ask questions like, well, do you know what the lockout tagout policy says? And if that employee says, no, I've never heard of the lockout tagout policy, even if the employer has one, the failure to train that employee on the policy can be a problem, can result in a citation. Now, you compound that problem if you've got foreign workers who don't speak the language well enough. And so not only are you not training your English-speaking employees on it, but you may not be providing resources to those foreign language speakers, allowing them the same benefit, the same protection, the same information that you should be providing everybody else. So the language issue becomes another problem in this health and safety context, particularly from OSHA's standpoint, but in a lot of other ways as well. So again, a language is important, and you have to be prepared to address that concern when you're involving foreign workers in the workplace.
Where would an employer find a good interpreter? We are so lucky to be in Cincinnati. I mean, come on.
Right.
We've got some fabulous resources, but just atypical. Somewhere, where would they find an interpreter?
There are a lot of wonderful interpretation services locally. In Dayton, we've used a number of companies. There are several services down here in the Cincinnati area. The other place you'd often want to look for, not every language service organization has capabilities in some of the more obscure languages, and so we've often gone to the universities and looked for folks in language departments or people who are foreign students perhaps who are here in the United States studying on a student visa in this case, for a few years. They may already have good English language capability, and they may be from Ethiopia speaking Tigrinya or whatever the particular language requirement is, and so we would possibly bring them in to help us translate. So there are lots of places, but thinking outside the box is sometimes useful too. And we've also tapped into local communities. There are sometimes folks who are here in the United States who have an ethnic background, and they may know people within their own ethnic community who have great language skills. They've been U.S. citizens for a long time, or green card holders, or they may be here just visiting, but in any event, there may be people in those local private communities who have great language skills, and we're sometimes put in touch with those folks. So sometimes it takes effort if we're talking about a more obscure language or dialect that isn't always easy to locate somebody with expertise in. But there are lots of different ways to go about that. And again, I think most of the legal services that you find that do immigration assistance, immigration work, or immigration compliance usually have connections with organizations, as we do, that can provide appropriate translation skills when needed.
And getting someone as close to that knowledge base is always helpful too. We were talking about that a little bit earlier.
Yeah, that's a great point, Pandy. I was telling you a story about a deposition I was involved in recently where we had a Japanese executive who spoke fairly good English, but the difference, of course, between conversational English and technical English, particularly in a deposition context, is pretty important. Understanding a question in a deposition is important, and so that the technical and the language nuances aren't always easy for a non-native speaker to pick up on. When you get a translator, which we did in this case, that translator sometimes has to understand the process of a deposition before they even come in the door. It's one thing to know the language. It's another thing to know the language and know how a deposition works and what an attorney does, what a court reporter does, how the process works, because that helps that context makes the translation a better translation. It makes it more precise, and it also makes it more effective, I think, in the end. So having someone with appropriate context and background helps a lot. It isn't always easy to find. You may not always be able to find someone who speaks Tigrinya and knows health and safety. That's a tough thing, but certainly, if it's possible to find someone like that, it's better.
I love it. We're just touching the very tip of this iceberg, and we really need to go even further in terms of the documentation, the literature aspect of it, and that's exactly where we're going to bring Josh Sherlow in. Stick with us in our second half. We're going to be talking about all the legalities around that, the record keeping and the paperwork, and how we can really we're not going to miss a thing. Josh is going to tell us exactly what to do. Stay with us.
Leaves us with the next item on our agenda is item number 5, opening session.
I want to thank everyone for joining us this evening. If you're out here at the parade or listening, thank you again.
Into the end zone, and that is caught by Jaden Wood.
Come on now, how we doing? Y'all feeling all right out there?
Hello and welcome to this edition of This is Glendale. I'm Bet Chorus.
Hey guys, this is the Unit 1 crew from Woodlawn Fire Department. We just want to wish you guys a Merry Christmas and a Happy New Year.
And of course, you can always go to ICRC-TV.com.
Always a great day when ICRC is involved.
Another edition of ICRC, bringing the community to you.
Thank you for staying with us. Today we're talking about foreign workers in the workplace. We've got to get this out on. I mean, we got to talk about all these details. Carl did a marvelous job in the first half of the show talking about how to obtain, identify, and actually think about what we need in terms of foreign workers. But once we get them, or once we know we're going to actually go through the hiring process, let's now talk about all the legal paperwork and documentation, because as Carl mentioned, we've got to make sure that's absolutely perfect, and we can't treat them any differently than we do our American citizens. So Josh, this is your turn to absolutely shine, because I know immigration is one of your favorite topics.
Well, thank you, Pandy. It's great to be here. I appreciate Carl bringing me along today. One of the things I think it's important to kind of mention right out of the gate is, what do you have to do with an employee once they start? And the first thing you have to do is verify that they're eligible to be a U.S. worker, okay? And we do that through the I-9 form process. And what that essentially is you have to identify or verify the individual's identity as well as their authorization for being employed in the United States.
Okay, now I'm going to stop you right there because there's so much confusion around that crazy I-9. So when you talk about hiring, you mean the offer has been extended, the individual has accepted. This is not during the interviewing process.
That's a wonderful point, Pandy, because I think it must be pointed out that you cannot verify, you cannot do the I-9 form until after the employee has accepted the offer. Once they accept the offer, that's when you go through the process of completing the form. There's 3 sections to it. Initially, only 2 are applicable to the situation, and the first one primarily is for the employee. And it's at this point where the employee, on the first day of employment, the first day they're there, they have to complete that first section, which has to do with their identity and, again, their authorization for being a worker in the United States. Within 3 days of completing that form, they have to provide certain documentation to the employer, okay? And there's a list. If you look at the I-9 form, it's all laid out there, passports, social security cards, whatever they may have, but you have to provide this documentation that substantiates their identity and their authorization. So that happens within the first 3 days, and then the employer has to verify that basically what they do, typically I should say, not right now because the world's a different place, but traditionally what would happen is the employer or a representative on behalf of the employer would sit down with that employee and go over that documentation. And come back, or the idea is that we're looking at this and verifying that it's genuine and accurate. And that's the second part of the I-9 form, which is the employer's responsibility. So let me take a quick moment and tell you how things are a little bit different now, all right? So nobody's a stranger to COVID and how that's changed the world these days. So with this process of verifying that information, the employer's responsibility, there is now the opportunity to do this remotely. Now this is new, and this has been going on, I think, for about a year now. But they can verify, they can skip the in-person verification process, and they can do this remotely, and they can onboard this information that's relevant to the I-9 remotely now. This is not a permanent situation. Looking at the guidance that I reviewed prior to today, it is the indication is that this will go away at some point. So it's not a permanent fix. The other thing to keep in mind is this is for remote employees. But if that employee should come into a more permanent either workplace or office place situation, the employer then has 3 days to sit down with that employee and go over those documents that they presented as part of that I-9 process.
Okay, so let me walk this back through. We have someone who's not coming into the office. We're going to onboard them. We can use FaceTime. We can use Zoom.
You can use email.
Email.
You can use email. You can use fax. The guidance says email and fax, video, all that.
Oh my gosh. But when things go back to normal, because we all know they're going to, right? We still have to do the tactile.
You still have to sit down, hold the papers, verify that they're genuine and accurate with the employee. It's not just taking them, printing them out. You have to sit down with the employee and do what you would have traditionally done but for this remote process that's been introduced.
Josh, you just hit on one of the questions. You just led right into one of the questions. We may keep you. So many of the payroll companies, and we've talked about this earlier on the show, but let's go over this one more time. Almost all the payroll companies that have online onboarding include the I-9 in that process. Please go through the steps our employers need to be aware of, because many of our employers are not printing those I-9s off out of that payroll system. They're not touching that form. They're allowing the employees to put the document information in, and they're not looking at documents at all.
So essentially they're taking the information directly from the employee and just putting it in a personnel file.
No, it's all staying in the payroll.
It's all staying in the payroll.
All staying in the payroll platform. So there is no paper at all.
Well, I would say that they should probably call us, and we can help walk them through the correct process. But putting that to aside, the remote process now does allow them to do things electronically that traditionally they were not allowed to do. But these employers technically should be sitting down with these employees, taking that I-9 information, going over it, verifying that, again, genuine and accurate is the key term there. Yeah. And then, they have to complete out that employer form portion of the form as well. Mm-hmm. Now, one thing to touch on too, when we're talking about the forms themselves with the I-9, if they're doing this remote option where they have to verify that they've looked at the documents, they can note on there that it was remotely done, okay? But when they ultimately have to sit down with that employee and do this in-person inspection, they need to go back and change that form and update it to reflect the fact that they did do this in-person inspection.
So let's also, as I'm auditing I-9s with clients, one of the biggest oversights that I get on page 1 is the question, was there a preparer or a translator? Did I prepare this myself? So talk about the importance of that box as we're talking about foreign workers.
Well, I mean, the information that we are keeping as part of this I-9 can be inspected at any time, right? Mm-hmm. So the enforcement agencies can make a request to see that information. If we have foreign workers that have dialogue barriers, and now we're expecting them to complete these forms that, oh, by the way, verify that they are allowed to be in the United States and working as a U.S. employee, well, that presents a number of problems. I mean, I think that that's going to put a larger microscope on the company from these enforcement agencies, but also it kind of undermines the sincerity of the form itself. And it makes you wonder, what else aren't they providing for these employees that have a language barrier? Carl touched on some of those today about different personnel policies, or even things that we may have to post around the office that advise individual employees of their rights as an employee with that particular employer. I mean, things of the posters that we have to put up about workers' compensation rights and different things. That's all stuff that should be made available to these workers in a language that they can understand.
I love that, because so many times, I know Travelers is one of the providers for workers' comp for a number of states for one of my clients, and they will send me the Spanish-speaking poster as well as the English. Yes. So I just challenge our viewers, if you've got individuals outside of that language, you need to be going back to a Travelers or Chubb or whoever your provider is, if it's outside of Ohio, and ask them for that particular language. Because you can order federal and state labor law posters in all sorts of languages.
Right. And
those have to be posted for these foreign workers.
Yeah, and I think my advice to these employers would be proactive about this. You have to be proactive about this. We touched on some of the stuff earlier about, whose responsibility is it to get the translator, the employer, or to provide a translation of a particular document or policy or personnel guide. And my advice would always be, you have to be proactive as the employer and anticipate some of these issues before they arise.
Yeah. Let's go back to something that Carl was talking about as well in terms of training. At the break, we both, or all three of us, kind of chuckled and said, you can't give a foreign-speaking employee an English-speaking acknowledgement that they were trained in something. You can't put them in front of an English-speaking lockout, tagout training program. You have to go that far in terms of preparing for them, correct?
Oh, absolutely. And in fact, I was joking with Carl on the way up here. I said, Carl, have you ever bought anything from IKEA? The manuals and everything are impossible to read, from IKEA. And so I think to myself, if you're an employee and you're giving some type of guide on a particular piece of equipment and something that you don't understand, well, that's just borrowing trouble at that point if you're the employer. Because how do you justify that later if you now have an injured employee on a device, that maybe didn't understand the proper safety mechanisms, or maybe the routine that you're supposed to go through before you operate a machine, whether it's with a foot pedal and side buttons or different things like that. Those manuals that were given these employees that train them on how to use what in some ways can be dangerous equipment is crucial to keeping your workforce safe.
You do a lot of OSHA.
Mm-hmm.
Give our viewers just an idea of what a fine would look like if we don't have the same safety posters. And in a manufacturing setting, you have to have certain safety posters. Mm-hmm. If those aren't representative of the foreign workers that we have on the floor.
Sure. I mean, there are different levels of fines depending upon whether it's a willful violation or a technical violation, and some of those fines can go up well into the six figures if they're repeat and multiple. But at the end of the day, I think, for the most part, if you have a process in place, if you have developed a procedure for training, and if you have identified any individuals who have minimal English language capabilities, and you've accounted for that in some form or fashion, OSHA is going to look at that and consider it as a mitigation of damage. So if you've made a good faith effort, mm-hmm. As opposed to simply ignoring the problem, mm-hmm. which a lot of employers do, but if you've made a good faith effort, even if maybe you haven't been successful in parting some nuances across the language barrier, those fines and damages, penalties are going to be mitigated to some degree. There's always a process whereby you go through with the OSHA investigator and talk about, the efforts that you've made, successful or not, to try to, to try to get to the optimum result. So, the fines are going to vary depending upon, again, your good faith compliance and your efforts in making that attempt.
You're such an attorney. I ask you for an answer and you give me a broad base. Here, the answer is you don't want to pay it. No matter what it is, you don't want to pay it. So if it means you get a new handbook in French or another handbook in whatever the language is, you do it, right?
Yeah, absolutely. And on the issue of fines, I mean, there's also civil fines that can be imposed for not doing the I-9 forms correctly or not maintaining them in the fashion you're supposed to as an employer, you know?
Yeah.
I want to raise one, to Josh's point about the I-9s. You know, one of the things I think we encounter every once in a while with foreign workers and HR departments in particular is there's kind of a built-in trap with I-9s, particularly with temporary workers. So those temporary that we sometimes call them employment authorization documents, an EAD, or an H-1B visa, which lasts for 3 years and can be renewed for another 3. These things have deadlines, right? And so when you're hiring somebody and you're verifying their visa status, you get the document and it's going to have a deadline on it. You're going to say, okay, in 3 years, then that authorization is going to go away. So it might be, your I-9 might be valid and it might confirm their ability to work in the United States for a period of time, but keep in mind that where there's a deadline, you have to recertify at some point. And if you forget to do that, if you don't calendar that deadline and you don't monitor it and be prepared to step up and do that at some point, you could be hitting a point where you're actually not in compliance anymore. You were originally, deadline is passed, now you're no longer in compliance. You have to recertify, re-verify with the renewed document, with the new visa, whatever it is. And that can sometimes be a trap. I think you've encountered that a few times.
Yeah, it has. And this actually ties right into some of the things Carl was talking about earlier about, you know, the planning process that goes into hiring foreign workers and visas and how the extension requests and things like that. You know, as you're starting to think about these different timetables that you have with your employees and when you need to start moving for an extension on an H-1B, you also need to be thinking about all those other associated documents that you have to be re-verifying, you know, or considering as well, like the I-9. So it all goes together, and I think, you know, having good guidance, having good counsel, that kind of keeps everybody on task with making sure we're checking all those boxes really can help an employer maintain its efficiency.
Well, I wasn't going to use this as a training tip, but I'm going to throw one in. You know, it's interesting that we're talking about foreign workers, but how many times are the recruiting teams or the teams that are doing all the interviewing, and there's always, most employers, I don't care what the industry is or what the discipline is, there's always going to be more than one interview. How many times are we preparing those individuals to understand how to have a compliant interview when we're dealing with individuals who may not speak clear English? And you know, that's very, very important because they may have religious expectations, you know, of practices or limitations on dietary. We don't know. So how do we prep an employer to truly understand how to interview these kind of individuals?
Well, I'll let Carl jump in, but
yeah, I mean, I think one of the things we always preach, and it's probably applicable here too, is that when you approach the interviewing process, you have essentially, you know, basic questions that you need to ask.
Yes.
And I think you want to be careful that you're maintaining consistency. You would do that anyway, right? You're not gonna alter your interviewing process for a particular person with a particular background necessarily. You're going to fill the position. You know what the job description is. You know what the job requirements are. So if you're going to compare everybody across the board equally, you're going to want to ask them the same questions. Having said that, if you have a foreign worker who's otherwise qualified to work in the United States, but may have a language barrier, I think it's appropriate to consider whether, if you can do this, to find some way of making sure those questions are clear and understandable in the language that that person understands. Because really, that's the only way you're going to be able to do a fair comparison, you know, apples to apples, as it were. You could get you can't get, you know, comparable information from two different candidates unless they both understood the same questions. So in the same way. So again, that's, I guess, overall, that's how I would speak to that. Josh, did you have anything?
No, I was just going to say, just kind of drum on fairness, making sure it's fair. You know, if you're asking questions to an English-speaking applicant and they understand you, I mean, that should still apply to a foreign worker as well, somebody you're bringing in. If you need somebody as a translator to come in and assist with that, because maybe there's a defined role, like we've talked about earlier, somebody's coming in because of a particular target group that they want to hit or a particular population, you know, just making sure that the process is fair and you're giving them the same opportunity to interview for that position that you give other workers.
And the accommodation aspect, we have to remind our employers that if an individual says, I'm not available on Wednesdays because I have to be at a particular location to exercise my religious rights, we have to take that into consideration.
That's true.
As well as maybe even their dress code.
That's true.
Or apparel requirements.
Right. I mean, the rule is, and the basic rule in Title VII is, as many people know, who have worked with foreign workers, is that, where they have different religious expectations, religious accommodation works a little bit like, not quite the same way, but a little bit like disability accommodation. If somebody has a particular religious requirement that they need to observe, it's a sincere, true belief, part of their religious observance, the obligation then shifts to the employer to make reasonable accommodation for that. Now, that doesn't mean they have to do everything the employee asks any more than they'd have to do everything a disabled employee asks for, but a reasonable accommodation, emphasis on the reasonableness, unless it imposes an undue hardship on the organization. And in many cases, that may, as you put it, involve modifying a work schedule, allowing time off for prayer during the workday, if that's possible, and reasonably, if it's reasonable to do that given the work schedule and the work demands. And so, we approach a religious accommodation in some ways, a lot of the same ways we would approach an accommodation in the disability or medical context too.
The key factor there is what Carl just mentioned, is the sincerely held beliefs. And sometimes that takes some investigation on behalf of your HR department to sit down with that employee and kind of get into those beliefs and what they are. And it can be fact intensive at times. So,
but it is something that individuals should be coached on, and a labor law attorney or a really good consultant can do that, because again, the more foreign workers that come into our workplace, we're going to have these kind of things. These are uncomfortable situations for individuals who aren't prepared.
Yeah.
Right.
And they're easy situations for those who are prepared. So this is,
right.
You guys are doing all exactly where I want you to go with this. I want to hit one more topic though that I want our employers to really think hard about. And you and I have had previous shows on this topic. When you bring a foreign worker in, again, sometimes it's uncomfortable for the workforce, and there's a possibility and high likelihood that there possibly will be harassment, or an environment that shifts because the culture is not the same, or things are being different. Our employers need to understand what to look for when there's a possibility of harassment. And Josh, what would be your advice?
Well, I mean, this just goes back to something I was touching on earlier about being proactive. I mean, you cannot disregard somebody's complaints. If you have a foreign worker that has come to you and expressed some issues that he or she may be experiencing, on the assembly line or in a cubicle or whatever, that they feel is harassment, you need to get right out in front of that, and you need to address it with the employee that's been accused of doing something inappropriate, as well as the employee who's making the complaint. And document, of course. Document whatever you're working on with these individuals. And make sure that if you come back with a finding that something inappropriate happened, that you have to address it with that particular infringing party, and make sure they understand that, why this is insensitive maybe, and what the employer or what the company will not tolerate.
Yeah, I'd only second what Josh has said, and I think proactivity is as much about rooting out things that haven't been complained about, observing, not even necessarily waiting for a complaint.
There you go.
But, the supervisor walks through the facility and sees something up on a screen. Now, nobody's complained about it. Oftentimes, people are aware of it, but haven't complained because they're afraid to, which would be a problem for other reasons. But the supervisor's responsibility in this area, much as it is with any kind of harassment, particularly sexual harassment, is that, if you see something that looks like it might be offensive to someone, whether it is to you or not is beside the point. You have to be prepared to put yourself in the minds of others. You have to be empathetic, I suppose is the right way to put it. In any event, you have to address that even before a complaint comes to mind. And this happens in the religious context as well. And I think that's not always that's not always easy for supervisors to understand because, you know, they're getting the widgets out the door. They're trying to get the production running. They're trying to make sure everything is working the way it's supposed to be working. The last thing they want to worry about is something up on a computer screen or a poster that's hanging in a workstation someplace. But you know, that's really very important. And when you train on harassment, as you do very often, I know, Pandy, I'm sure you, and I know you talk about those kinds of things as well.
Well, and I also put a lot of emphasis on the quiet harassment. And
Right.
there's, you know, we all know there's about 8 different levels of harassment. Notice we're not talking about sexual harassment, we're talking about harassment. It's that quiet harassment of alienation. When someone different comes into the environment, same thing with transgenders and some of our sexual orientation situations.
Sure.
They come into the environment, people don't quite know how to handle it, so they alienate. And what happens for the company is that can cost the company thousands of dollars because maybe we hired them for a expertise or knowledge that they should be contributing to the company, but nobody's willing to bring them into the meetings. No one's asking them for their opinion. No one's asking for them to contribute. And that in itself is a form of harassment.
Now they feel marginalized, and
There
that
you go.
affects the overall culture of the workplace, and certainly that's a problem
There
on
you
so
go.
many levels, yeah.
Yeah, the world has changed, had nothing to do with COVID. Did you notice that we didn't say COVID at all today?
Yeah.
I want to congratulate you. But yet
We could
it's
still talk about COVID.
This is still a real subject. Foreign workers in the workplace. I really hope that by you watching the show that you understand a little bit more of all the challenges that we as a nation have to start facing if we're going to keep our small businesses going and vibrant and be able to use the skill sets and the disciplines and the blessings of foreign workers coming into our country right now. Josh, I want to thank you. Thank you so much. Josh Sherlow, Carl Ulrich from Sibley, Shillito, and Dyer. Where are your offices?
In Dayton, Ohio, in Westchester, Ohio, and in Eaton, Ohio.
And Josh, how can they get a hold of you?
They can get a hold of us by calling our main number, which I never call, but I believe it's 222-2500.
Somebody pull
Is
your
that
cell
right?
phone.
Yeah, so
Something like that.
I never call the main number, you know, so I think that's what it is. But certainly if you Google us online, you'll find us, and give us a call and we'll see what we can do for you.
You know, and that's the important thing. Remember, any of the speakers that I bring on the show, we bring them on specifically, not only for their expertise, but for their willingness to help you. You've heard it said on this show over and over and over again, surround yourself with people who are better at these topics and who specialize in this stuff. A great CPA, employee benefits, always a good labor and employment lawyer. So take my word for it. I'm Pandy Pridemore, Principal Consultant with the Human Resource USA. I want to thank ICRC-TV for one more hour, and we hope to see you again. And I'll be very truthful. I can't guarantee that we won't use that C word in the next show, but come back and find out. Thank you.